Ron from Ron Rode Law, and together with a.cre, we're going to bring you this LOI, letter of intent for a multifamily property.
Hey everyone, Spencer Burton here. Allow me to introduce Ron Rode. He is our a.cre legal contributor, and he'll be sharing a walkthrough of one of his real estate legal documents.
Ron from Ron Rode Law, and one of the things that we do a lot is work with buyers to create documents for their own purposes. You know, I think it's kind of this misnomer that maybe once you have an attorney, you have to use them for every single thing that you do legally, any documents that come out of your office. And I think the flip side is DIY, right? The flip side is not that you do every single legal task and you say, I can do it internally. I can read contracts, I can read paper. And so, you know, hopefully this is a useful template that if you're thinking about submitting an offer and you just want to see what other LOI terms people are putting in there, this is what we see in the market. We do a lot of multifamily transactions, especially on the buying side. And so I'm going to walk you through this LOI. Again, if you haven't watched some of my other LOI, it's an art and a science, but an LOI is a really important document because you never have a second chance at a first impression. All right, so let's dig into this document. Again, I think opening with a logo, some type of, clear indication of who's writing this, your address, a physical address these days is really important. It helps ground them. Are you local? Are you out of town? Not anything good or bad, but you just want to see that type of information. Date that it's submitted, that's going to be important later. Seller name. It's not a big deal, but it does impact on my sellers, and I have had feedback that people care that you spell their name correctly. The address, less so important, but make sure you do that time to accurately write down the seller's name. The subject here, letter of intent to purchase. Property address, maybe a common name. So if the apartments have a trade name, the View or Harozaki Apartments, and the number of units. I think that's really a good way to show your due diligence and convey what you understand the number of rentable units to be compared to what somebody just looking up the address and making a wholesale attempt. They don't really care how many units it is. They're not going to buy it. They're not going to own it, operate it. They just want to get it under contract and flip it. So do a little bit of due diligence and make sure that you have your assumptions out here. Again, so we have this, this letter of intent to purchase to outline the terms and conditions. The number of terms and conditions that you put is a really complicated question. And the answer to that is you want to put the least amount of terms into the LOI that are deal breakers for you. So what I mean by that is the shorter LOI is going to have more traction, and it's going to be faster and easier for you as a buyer to push out more LOIs. So it just becomes a numbers game when you're buying in commercial real estate, is that you have to make lots of offers and you need to be able to quickly spin up LOIs based on properties that you are interested in. So you want a short LOI to convey exactly what you want to buy and to be able to quickly spit them out. On the other hand, you do need enough detail in the LOI for deal breakers, and that's true for both sides, but you want to convey enough information to the seller that we absolutely need insurance loss runs. We need rent rolls. Those are absolutely critical for us to be able to close on this property. And so that's a type of due diligence document I would put in there. But it's a trade-off, I think that some of the more complex properties, certainly if you're making a portfolio offer, it's going to have a very long and detailed LOI to make sure that the seller understands what they're getting into when they go under contract with you, as well as the various terms that are going to be put into the PSA. If you get into a PSA situation and you terminate because you can't come to agreement on PSA terms, it's just a waste of time and money for everybody. So let's keep going. Real property, the number of units, multifamily, maybe if it's mixed use, it may have a retail component. Just put it in here so that you are clearly talking about the same property. Exhibit A, that's up to you whether you want to attach a legal description. I see it a lot more for multi-parcel offers. You really want to be clear on what you're offering on. Buyer name here, this should be your SPE. It has no assets. It needs to be a shell company that it's a land code just for contracting, no assets in case things go sideways. Seller, fee simple, okay, fine. Purchase price. That's pretty obvious. You want to put that. I just say lead with it because it's going to dictate the rest of the LOI if you have a competitive price. Earnest money deposit, more is better. I think, we're still in this weird quasi seller's market. Maybe it's shifting to buyer, but you still want to show that you're serious and put a decent amount of money down. For 3 business days, I think that's normal. Anywhere from 3 to 4. I don't really see 5 business days, but anything shorter than that is pretty quick. So 2 to 4, how about that? Non-refundable. Are we going to have non-refundable earnest money? It really just depends on the market. It depends on the property. We still are seeing non-refundable earnest money on deals. It really is for good properties at an attractive price. The seller really wants that. You can be willing to put that in with maybe some carve-out exceptions to title objections, environmental issues, or survey results. Escrow holdback. This one's a new thing. This is a little bit more interesting, where we have this gap between seller sales price and buyer purchase price. If there's a big gap, the escrow holdback can be really used in some creative ways, and work with your lawyer on this. But let's say there's a higher percentage of leases that are turning in the next 3 to 4 to 5 months. And you say to the seller, I'm very concerned about those people re-signing at maybe market rate. The seller, of course, he's going to say, no problem. They want to stay 100%. I guarantee you they'll stay. And you say, okay, I'll pay your asking price. I'll pay $11 million, but only on the condition that 50% or 70% of those leases in the next 6 months renew at market rate. And the seller will say, well, that's definitely going to happen. You should just trust me. And you say, no, I trust you, but I want money in escrow so that if 50% of leases don't renew, I can get my money back or some portion. There's a lot of mechanisms that are fair, because you as a buyer are saying, look, I'm willing to pay top dollar, but only if a certain financial outcome occurs within the next 3, 6, 9, or 12 months. If the seller has a high degree of confidence in that event occurring, they should agree to the holdback, because that may be their only option or their only way to sell this property and get their max value. And so the escrow holdback, to me, is really is a great way to call out people on what they're saying. And if there's not a lot of competitive offers, this is the only way the seller can get top dollar, is to have an escrow holdback. Again, it's more complicated. It costs more in legal fees. There's some risk, but it does allow buyers and sellers to bridge that gap, where it's if this occurs, then you get your money. If it doesn't occur, the buyer gets to keep it and get a refund. Due diligence period, we have 30 days. I think that's pretty standard depending on how much information you have. Extensions, we really like to see a little bit in here about what do you realistically expect for having an automatic right of extension. You have an additional earnest money deposit. Again, I think that's a sign of good faith. You can specify here whether it's hard earnest money, whether it's still refundable. Maybe it's applied to the purchase price, it's not applied to the purchase price. Lots of different variations you can do just to make that extension very competitive. But talk to your lender and your equity partners and find out what you really need to be able to close the deal in this environment. Access, this one is pretty standard. If you're out on space, I might delete this. That's not super unique. Due diligence, this is important. Unit mix, lot size, management space, amenities, parking spaces, any copies of phase 1. That really, I think, conveys to the seller that you're serious, you know what you're doing, and these types of documents are going to be critical to your underwriting while you're under contract. Closing 30 days after the due diligence, maybe that's a leftover of rapid closes. You may want to push that to 45 or even 60 days. I don't know how competitive or how much time you need, but it's certainly a consideration to have a 30 plus 30. Transaction expenses, again, I think other than commissions, that's the biggest one, but you have your base title policy, maybe the seller pays. This one, they have splitting it. That's fine. Just think about it. Each party pays their own attorneys. I think that's always common. Other closing costs, again, nothing is really a deal breaker in terms of a percentage or absolute number. It's really the commissions and title policy that are the biggest expenses. PSA within 10 business days, again, totally reasonable. That's 2 weeks. I think a minimum would be about a week, and on the long side, it can be 2 to 3 weeks as well. Confidentiality, exclusivity, non-solicitation. Are these enforceable? Those are really great questions about an LOI. And I think here, my point is this is a non-binding LOI. So to the extent that these are legally enforceable, it's not a great argument. However, it is a small world in commercial real estate, and you should really respect these clauses if the other party is expecting it. because you will be a seller someday. If you buy this asset, then you'll be a seller, and you don't want the buyers to have this kind of cavalier attitude or laissez-faire about the terms of these discussions. And CRE is a small world, so if you violate these, if you breach these in quote bad faith, it's gonna come around. All the parties are gonna know, and people aren't gonna want to do business with you. I think review these, understand what you want from it, but it's not really as enforceable. I have some CYA catch-all language trying to make it more legally enforceable. Again, we've had situations where my clients feel really aggrieved, or they feel really insulted by the behavior of somebody else, and they've come to me and say, well, what can we do? The reality is your damages are very hard to quantify. There may not be that much of a loss from doing it, but anyway, it's an attempt. I like this one. LOI should be valid. It has an expiration date, so it has 5 days here, but maybe you put 2 days, maybe you put 1 day. Put some pressure onto the seller and automatically make sure that this LOI expires, so that you're not crossing wires in terms of the expectations. So that's it. I would send it to the seller signed, so that they have that, and then all the seller has to do is sign on their side, and then boom, you've got a fully executed LOI. We've got some due diligence materials here. I just pulled this from what we've used in the past, but feel free to modify them with what you would want. And that's it. I think the multifamily LOI, it's really a critical piece, especially when you're having to sell yourself or make competitive lowball offers in this market. So spend some time, draft this LOI as you would expect it. Otherwise, smash that like button. Thanks for watching a.cre and Ron Rohde Law. We'll see you next time.